The purpose of this episode is to clear the air surrounding the pros and cons of a revocable living trust. The most important factor to consider when determining whether a revocable living trust is right for you, or if you are a financial advisor or a lawyer, whether a revocable living trust is right for your client, is where the person lives. Every state has its own rules, regulations, policies, procedures, and laws that govern what happens to someone's assets in the event of incapacity and at death. And unless you are looking at this question through the lenses of the proper state or the rules, regulations, policies, procedures, and laws that exist within that state, we cannot have a meaningful conversation about this. And I want to be clear and acknowledge why I'm recording this video. There are a couple of different reasons. Reason number one is that I get this question a lot. A lot of clients ask me whether they should consider a revocable living trust, and I want to be able to answer that question in a really meaningful way, exploring all of the potential pros and cons. But reason number two is, in a way, righteous indignation. I feel like there are way too many people who have put information online, whether it's in blog posts, in articles, in videos, even in national publications, that advocate for the use of revocable living trusts without acknowledging or without emphasizing enough that the individual states' rules, regulations, and laws dictate whether or not this is appropriate for a person. So with getting off my pedestal, I'll move on, but I want to be clear that in this video, we're going to use the example, or we're going to explore this concept, this idea, through Pennsylvania law. That's where I practice, that's where I live. And so while we're going through the pros and cons, many of them will be state specific, some of them apply more broadly. But in those instances where we are talking about state specific answers, we're going to be answering those questions under Pennsylvania law. So first, I want to give credit where it's due. There are use cases, even for Pennsylvania residents, where a revocable living trust makes sense. So starting with reason number one, if you are a resident of Pennsylvania and you own property out of state, specifically real estate. It's a good example. It's probably the most common asset that people own in other states. You may want to consider putting the real estate in the foreign state or the other jurisdiction or the state where the real estate is located. You may want to consider putting that real estate into the name of a revocable living trust. The reason is it avoids probate in the other state. So in a moment, we're going to see why probate in Pennsylvania is relatively straightforward and cost effective, and it's not necessarily a common goal to avoid probate in Pennsylvania, but in other states, it may very well be. So in states where probate processes are more difficult, more complex, or if probate fees are very high, or just to avoid having probate in two different states, it might make sense to use a revocable living trust. Reason number two is that revocable living trust can be used and can be pretty good at addressing the issue of incapacity. So just to kind of revisit the basics of the revocable living trust. We talked about this. I have another video that's titled, What is a Revocable Living Trust? So that talks about the basics. But just to revisit that really quickly, if you have a revocable living trust during your lifetime, in most cases, you will be the grantor, the person who creates the trust. You will be the trustee, the person who controls the trust, and you will likely be the beneficiary. There may be other beneficiaries, but in a lot of cases, the grantor, trustee, and beneficiary are all the same, and any assets that I move into the trust are retitled into the name of the trust. And what I can do in the trust document is name a successor trustee in the event that I would become incapacitated, so that someone else can step in very easily and manage the assets that are titled in the name of the trust if I'm not able to do it on my own because of incapacity. So that's the second reason. Reason number 3, this hopefully will not be relevant in the future, but during COVID, when a lot of government agencies shut down, that included the Register of Wills office. And so it was difficult for a pretty short period of time to, and I'm speaking only based on my own experience, where I live locally, we were affected for a relatively short period of time, but it was difficult to get documents. It was difficult to file a will or to probate. And so trust administration can be, in those instances, a little bit easier. But I do want to give credit to where I practice in Lebanon County and the surrounding counties, so Lancaster, Dauphin, Schuylkill, Perry County, some others. The courts were really good about making accommodations for remote transactions. So it was actually pretty easy for us to file for probate during that time. Now I'm going to make a case against the use of a revocable living trust. First, I want to talk about 2 common misconceptions. Number 1, revocable living trusts do not save in tax. They do not save income tax, they do not save Pennsylvania inheritance tax, and they do not save federal estate tax, period. Assets in a revocable trust do not avoid tax. Number 2, revocable living trusts do not offer creditor protection. So if I have a creditor claim, someone files a lawsuit against me, it could be for a civil dispute, it could be for a motor vehicle accident, they get a judgment against me, maybe I didn't pay my credit card bill, and they file a lawsuit and they get a judgment against me, any other claims that can be filed against me. If I move all of my assets into the revocable trust, it does not make any difference at all. All of my assets in the trust are subject to my creditor claims, and that's true during my lifetime and at death. Once I die, if I have creditor claims, the assets in the trust, even though at that point they may become irrevocable, they do become irrevocable, the creditor claims are still out there and the assets in the trust are subject to them. Now I'm going to address common arguments in favor of a revocable living trust and talk about why in Pennsylvania, in many cases, it does not matter. So, reason number 1, they avoid probate. This is true. Even in Pennsylvania, assets that are titled and properly funded in the name of a revocable living trust avoid probate. But in Pennsylvania, the complexities of estate administration and probate that exist in many other states are not an issue here. So the probate process in Pennsylvania is fairly straightforward. Probate fees in Pennsylvania are relatively low. So probate avoidance is not a common rationale for using a revocable living trust in Pennsylvania. I often hear some variation of this same argument. Something like revocable trusts are easier to administer, or the assets in the trust are not frozen like they are in probate. And so the beneficiaries of the trust can receive their distribution from the trust a lot more quickly than they would get those same distributions from an estate under a will. And I have to say that in many cases, that is not true in Pennsylvania. And to illustrate this, or as proof, we're going to refer directly to the law. Under Pennsylvania law, the trustee of a trust upon the settlor's death must abide by certain provisions within the PEF code. So let's take a look at some of these provisions, and we'll see that trust administration is very similar to estate administration. So, for example, a trustee must provide notice to the personal representative of the decedent's estate. So this is where there is still reason to probate. A lot of times that's because certain assets were never moved over into the trust. And so there is going to be an estate administration, probate, and there's also going to be a trust. And so there is trust administration. So the trustee must provide notice to the personal representative. So that may be the executor or the administrator of the decedent's estate that the trust exists. The trustee must also provide notice to the decedent's spouse. They must provide notice to the decedent's adult children and to any beneficiaries of the trust. The trustee is required to respond to any requests for information from the beneficiaries. In order to create a statute of limitations, the trust must be advertised. And so that's a similar rule that we abide by in estate administration. The trust may be responsible for the payment of inheritance tax. Often they are, and we mentioned earlier, are subject to creditor claims. So why does all of that matter? Put yourself in the position of the trustee. You are now in a fiduciary role. You're serving in a fiduciary capacity and therefore are subject to the laws of the Pennsylvania Probate Estates and Fiduciaries Code. So you have a legal obligation to act in accordance with the terms of the trust, to act for the benefit of the beneficiaries, and you have to follow the law. So, very often, a trust is set up so that payment of any estate administration, funeral expenses, inheritance tax are payable out of the trust assets. So when someone dies, you'll have bills coming in, could be medical bills, could be credit card balances, it could be final bills relating to home ownership. You're going to have funeral expenses. Inheritance tax must be paid. You'll have to file an inheritance tax return reporting all of the assets in the trust. And all of that should be done before any final distributions are made to beneficiaries. The reason for that is if you immediately distribute all of the property in the trust to the beneficiaries and then some kind of a claim comes in against the trust, or maybe a bill comes in, or maybe tax wasn't estimated accurately and the Pennsylvania Department of Revenue is coming back and saying we need more tax. If that happens, then you have to go out to all of those beneficiaries that you've just distributed to and ask them to pull back some of that money so that you can pay the bills, you can pay the taxes, whatever the case may be. So put yourself in the position of the trustee. You may delay making distributions until you know that all of those liabilities are taken care of. And if you're relying upon the statute of limitations that was created by advertising the trust, which is a year in Pennsylvania, you have to wait that year until you can be sure that any claim that's coming against the trust has been properly dealt with. So as the trustee, I would not feel comfortable making a final distribution to the beneficiaries until all of those things are done. And that is the exact same process that you have to go through estate administration. So we're going back to this argument of trust assets aren't frozen. They can go right to the beneficiary. Yes, technically that's true, but if I'm the trustee and I'm legally responsible for making sure that all of those things are done properly, I'm not going to be quick to make those distributions to the beneficiaries. So for that reason, trust administration is very similar to probate. The next argument that I hear is that trusts are more private. That is partially true, but in Pennsylvania, we talked about earlier, if there are assets in the trust that are subject to Pennsylvania inheritance tax, you have to report those assets on an inheritance tax return, which is due 9 months from the date of death. And it's a legal requirement that when you file the inheritance tax return, if there are assets in the trust, you have to attach a copy of the trust. And those documents are filed in the public record. So one way to address this, people title the name of the trust in a way that maybe isn't immediately identifiable with their name. So they may use initials or some other variation of the person so that they're not directly identifying the person, but it's still filed in the decedent's name at the courthouse. And the inheritance tax return has the decedent's name on it. So while it may not be as public as estate administration, there's still that factor to consider. Another argument that I hear often is that a revocable trust saves money. This is a complicated one. Arguably, if the trust is perfectly set up, perfectly administered, and you have a very organized client who's doing everything that they need to do to make the process as easy as possible for the trustee when they die, and if you avoid probate completely, which can be difficult to do, there is a potential argument that you could save some money. But in my experience, I've seen the opposite. I have never come across, in my experience, a trust that has been properly funded, meaning it is all of the decedent's assets were moved over into the trust, and all we're dealing with is a trust. We don't have to deal with any of the probate processes. I've never seen that, and what I have seen, however, is a revocable trust that is not properly funded, where maybe some of the assets were moved over, some of them weren't. So now we have to do trust administration and probate. And when that happens, the cost goes up because it's more work. You're effectively doing both administrations, and it can get a little bit sticky. It can get complicated. Also, the cost of setting up the trust is almost always more expensive than setting up a will. So for those reasons, I would argue that, at least in Pennsylvania, in the cases that I've seen, setting up a revocable living trust does not save any money at all. And in fact, it can make the process more expensive. Another argument I hear, or statement I hear, is that it replaces the will. It doesn't replace a will. It's a will substitute or a will alternative. But in most cases, your estate planning attorney is going to advise you that you should also have a will. Now, this kind of will, it pours over anything going into the estate back into the trust. But the reason that we recommend this, if you have a revocable living trust, that you should also have a will, is because often people don't do what they need to do to properly retitle all of their assets into the name of the trust. So you still have these things that are lingering, and the will acts as kind of a catch-all for those items, catches them. You have to go through probate, but eventually they're moved over into the trust and administered according to the provisions of the trust. Another issue that I've come across is realty transfer tax, Pennsylvania realty transfer tax. There are some very complicated rules about transferring real estate into the name of a trust and whether that transfer is subject to Pennsylvania realty transfer tax, which is often about 2%. It changes based upon the county that the real estate is located in. Where I practice in Lebanon County, it's 2%. So it can happen where real estate, when it's retitled into the name of the trust, depending on the trust provisions and the beneficiaries of the trust, it can trigger Pennsylvania realty transfer tax. So that's an issue to look out for. This comes up very often when people are residents of other states, but they own real estate in Pennsylvania, and they want to transfer the real estate into their revocable living trust. We have to really look very closely at the trust document to make sure that it's not going to trigger Pennsylvania realty transfer tax. One of the reasons that I'm creating this video is because there are instances where clients are scammed. They are talked into somebody to create these documents, and they can create a lot of problems for people. So this has gotten to a point where the Attorney General in Pennsylvania has issued a public statement. This is directly on the Pennsylvania Attorney General website. It's called Beware of Living Trust Scams, and it outlines a lot of the things that worry me about revocable trusts. I have clients who have come into me and they have these giant 3-ring binders that are a stack of legal documents that have all kinds of complicated trusts. And I've gone through them, and I have to acknowledge that in some cases, these documents are very well crafted, but the client does not need them at all. And in fact, in a lot of cases, they can create problems. They can complicate and way overly complicate a client's situation, and it ends up, not only do they pay a lot more money than they needed to pay up front, but unfortunately, often we have to unwind what was done previously. Again, I need to emphasize that this is coming from an attorney who practices exclusively in Pennsylvania under Pennsylvania law. So please, when you are setting up your estate plan, meet with a qualified attorney in your state. Thank you for joining me. I really hope that you found this information helpful. If you like this content, please let me know, and I'll look forward to seeing you in the next video.